Look, just in terms of I guess, preparing for the next financial crisis. I mean, obviously, with the share market crash in 1987, the finance company started collapsing about 20 years later. We don't know where it's going to come from, the next one, although, I mean, we're still dealing with the current one, really. But you do seem to have a little bit of optimism there that perhaps directors and trustees and others are perhaps going to have are going to be watched over a little bit more carefully than they have been in the past. You do seem to see some hope there that the FMA and SFO are perhaps playing a more proactive role now. Is that
yes?
Fair to
Even
say?
there, one has to be cautious about it. You see, the FMA had a case involving, I think it was Mr. Hodgkin's companies earlier this year, and Justice Winkelman said in her judgment, I think there was some attempt being made by the FMA to get a hold of some funds and to declare that they were impressed with trusts so that these could be accessed by creditors or investors or whatever. And the FMA, I think, had 3 counsel presenting the argument, and Justice Winkelman had to say that every time she asked any of them a question, the basis of their case seemed to change. They didn't seem to know whether it was an express trust or an implied trust or a resulting trust or a constructive trust. They couldn't explain it. So they didn't understand their own case, probably because, well, certainly because they didn't understand the differences between these various forms of trust and why they're significant. So, in other words, you had people who were arguing the case, a case in an area of law that they didn't know anything about. And so the FMA can be directed by the best people on the planet, but if they're going to put people up like that who don't know what they're doing, then the efforts will be wasted. I mean, all that case really achieved was to waste more money and throw more money after the stuff that's already been lost. So it's a case I think we've got to fix. We've got to start somewhere, sure, and there's a bit more feistiness about those two outfits than there ever has been about the Serious Fraud Office. And we've got to remember, too, that the Inland Revenue Commissioner at the time of the wine box pronounced mightily that there wasn't any evidence of fraud in the wine box. The Serious Fraud Office said the same, and the director of the Serious Fraud Office shortly afterwards was cross-examined at the Commission of Inquiry and asked to define fraud, and of course he couldn't. And it's a bit hard to be in charge of an organisation to hunt down fraud when you actually don't know what it is you're looking for. So the FMA and the SFO are a slight glimmer of hope, but there really is a huge swathe of other stuff, the legal profession, the accounting profession, and I think too the big firms are a problem. These big accounting franchises, they seem to sort of rely on size and the cachet of the name, and I just can't for the life of me understand how that name has any cachet anymore. There's, the list is very long of the scandalous company crashes all around the world that one or other of the big four have signed off quite happily, and either as auditors or accountants. And to me, they seem like prostitutes collectives, these outfits. And I think too they get a size where they can command because of their size. Governments then look at them, and same with big law firms. You don't necessarily find, you can find some very good people in those firms, but you don't necessarily find the best people, and certainly not in all the positions in those firms. And I think also the bigger the firm, the bigger the conflict that starts to occur, because the person who is the idea of the bar is that you've got, it's one-on-one. The barrister has no client, no competing client. He doesn't have a whole lot of other clients that he does all the work for, like a law firms and accounting firms do. This is a one-off job, all of them are. So he gets in there, he has no conflict, he has no problems, he fights like hell, and hopefully gets a result. But the big firms can have conflicts where, well, if they push this one too hard, it's going to annoy an even bigger client that they've got, and that sort of thing. And I think that's just a rotten way to conduct business, a rotten way to run an economy, and you end up with a rotten economy. And we're still a long way. We might have the first glimmering, but we don't know whether it's the light at the end of the tunnel or whether it's another damn train coming. It's very difficult to tell.
Well, thanks a lot for that. That's Tony Molloy QC, and I'm Gareth Vaughan from interest.co.nz with another Double Shot interview.